National Report Court back in session. Today, popular online clothing site Shein is being sued for allegedly violating the federal Anti-Racketeering Act by copying independent designers' works.
And taking up the case is Hunter
Shkolnik.
Sorry about that. Thank you. He is a trial attorney, and Doug Burns, a former federal prosecutor. Now, for the purposes of this segment, Hunter, you will represent the three designers that are suing Shein. Doug, you will represent the Chinese fast fashion retailer. So, Hunter, the artists say that Shein made exact copies of their work without their knowledge and then tried to sell it essentially as the original. I want to show you a side-by-side comparison of some of the designs involved. Can you prove this is copyright infringement and that it constitutes racketeering?
Well, the interesting issue here is the use of the RICO statute in this setting. And first, we would automatically be assuming this is a straightforward copyright infringement. And I would say, yes, you can. These are duplicates of the same design. But here, the idea is use the racketeering, influencing, corrupt organization statute, which was originally set up to go after the mafia, stop criminal enterprises. But it has morphed from that. We have used it in many ways. We've used it against pharmaceutical companies. We've used it against computer companies. When an enterprise is established between the defendant and other individuals, they don't have to be named in the case, to violate the law. And you have to violate a statute, usually a federal statute. Here, maybe the copyright infringement statutes. This falls squarely within RICO. They are a criminal enterprise, but a civil criminal enterprise is the allegation. And yes, you can utilize this statute for this very violation of the law.
All right, Doug Burns, you've heard out Hunter there in a few of the arguments that are made. What are your thoughts on it?
Well, the RICO law, which came in 1970, is primarily targeting organized crime, criminal racketeering, drug dealing, extortion, labor racketeering, etc. But they put in a civil provision which caused abuse by the plaintiffs' bar. And for decades, I've seen plaintiffs bring RICO cases for the reason of scaring the defendants, calling them criminals, calling them racketeers, seeking triple damages, which is provided for in RICO. But at the end of the day, and my colleague sort of had to grudgingly concede this is a copyright infringement case. It's not a racketeering case. And what's the old phrase? You can put a lipstick on a pig, Sean, but it's still a pig.
Still a pig. Hunter, we'll go to you back on this one here. This is not the first time, if you take into account Shein here, that they've been in hot water for something like this. This was put out here, again, in terms of copyright infringement. Shein has grown rich by committing individual infringements over and over again as part of a long and continuous pattern of racketeering, which shows no sign of abating here. Where do you see this case going? Hunter, your response to that, and again, where this case could go. Does that hurt this case?
No one's saying that they are a criminal. It is a civil claim. Congress, as well as many states, have incorporated this type of statute to be used exactly like this. You don't have to be the mafia. You can be a business enterprise. That's the definition. An enterprise that chooses to work with others to violate the law, whether it's the copyright infringement law or wire fraud or some other statute. And to gain a financial benefit. And yes, it does provide for treble, 3 times damages. This is a perfect example. They've done it over and over and over again. This has to be stopped. This is a way to stop it. And it is not overly aggressive plaintiffs, but thank you very much. This is what the law was meant for, and this will stop them.
All right, Doug, last word to you. Does Hunter have sufficient evidence to prove that the designers' businesses suffered as a result of this?
He has sufficient proof to establish an ostensible copyright violation, because I myself looked at 3 examples this morning online of products compared to the other products, and they have a good case. But it is not a racketeering case. That's my position. They are not engaging in racketeering as defined in the RICO statute.
All right, Hunter Shkolnik joining us live. We do appreciate that, as well as Doug Burns, if you could stay with us. Thank you. Thank you.
Thank
We'll
you.
bring in now Newsmax contributor Deneen Borelli here to play judge and jury, as we have our two attorneys present as well. You listened to this here, Deneen. What are your thoughts? You've heard both sides. Where do you fall on this case?
First of all, where is my gavel? Where
We're
is
working
it? That
on
will
it.
make it official.
Great.
Look, this $600 billion a year in theft with China, something clearly has to be done. I agree with Doug's perspective and aspect on all of this. China is a bad actor. China is a problem. Intellectual theft property is huge. Right. And how many articles and pieces of whatever that you have at your home that is stamped made in China, which could be a knockoff. So something certainly needs to be done.
If that were the case, by the way, Hunter, I'll go back to you on this one here. If that were the case and the judge came down on this one, if it gets this far, is that the end of Shein?
Oh, I don't think so. I think they'll find ways to continue in business. There probably are other members of the enterprise or related businesses that may not be identified at this point. And it's like whack-a-mole. I think you're going to take the head off of one, and it's going to pop off somewhere else, and we're going to see these products show up on our shores in violation of the trademark practices.
All right. Thank you all for joining us and for discussing this more. We appreciate it.
My pleasure.
All right, Doug Burns, Hunter Shkolnik, thank you very much, as well as Deneen Borelli joining us as well. We appreciate your time.